Good morning, folks who are coming in. We'll wait a few more minutes or seconds for folks to join us. Welcome to the third in a series of webinars this spring, put together by the River Management Society and the National Park Service, and our special guests who are experts in their own areas. My name is Risa Shimoda. I am the executive director of the River Management Society. We're thrilled that you're here, and we're gonna just make sure we've got folks coming in who want to be here. And I guess we can go. So I'll have these folks introduce themselves when they begin speaking a little bit, but our main stars of the day are Kelly Catlin from American Rivers and Dave Steindorf from American Whitewater, who's trying to be retired but can't quite seem to do that yet, and Kevin Mendick, who has recently retired from the Park Service, all of whom have decades and decades collectively of experience working on hydropower relicensing.
All right. Do I have the handoff, Risa?
Yep. One more, just just one more slide, Dave.
There we are. Look at those people.
Yeah, so those are the people you should see in your screen, and I'll just we'll ask for questions at the end. So if you could just keep yourself on mute, unless you're having technical difficulties, and please put something in the chat and we'll try to handle it. Okay, take it away, Dave
All right. I guess
or Kelly.
maybe Kelly and I will do just a little bit of intro. Yeah, Dave Steindorf with American Whitewater. Been doing hydro work for about 25 years. Participated in, I think, like somewhere near 20 relicensings and implementations mostly across California. So I've done a little bit, or quite a bit of that stuff. And then Kelly, go ahead.
Hi, I'm Kelly Catlett. I'm the Director of Hydropower Reform at American Rivers. And like Dave, I have been doing hydropower work both on the policy side and the relicensing side for about 22 years, primarily in California and the Pacific Northwest.
Yeah.
Hi, I'm Kevin Mendick. From 1990 until last month, I was the hydro program coordinator for the Northeast region of the National Park Service. I focused on projects from Maine to West Virginia.
So maybe, Risa, maybe I'll talk a little bit about my understanding of the genesis of this presentation. Last year we did one and we got some feedback that a lot of people wanted to know more about the FERC process and um, about how it works in practice and what are the things that you don't see when you look at the ILP flowchart, which is really, pretty simple, step by step, go through the squares, easy to understand. I'm kidding. It's none of those things. But really, like, what are the things that you need to know as you go through this process that aren't articulated in this flow chart? And so that's really kind of our quest today, is to unpack some of this stuff. So FERC realizing we're really going to focus on the ILP today. We might talk a little bit about the TLP. I will own that I have never done a TLP. I think I'm happy about that. I think the ILP is a much better process, allows for better stakeholder engagement. But that's one of the things that's at the very beginning of the process where the applicant will needs to choose with FERC's approval about which process they're going through. So in theory, if you look at the timelines that are on this flow chart, the process should take about 5 years. Quite often they can take longer, but not because of the pieces in this flow chart, but things that happen, along the way that can extend that timeline. Things like getting water quality certification, approval for FERC, or just one of the things here, there's no real deadlines for FERC in here. There's deadlines for everybody else, but FERC can really take as long as they want to finally issue a license. The Does require consultation with tribes, agencies, the public, NGOs out there. So there are multiple points for engagement, but particularly at the beginning, it can be quite busy. Uh, one of the most important parts of the process is getting the studies and really the information that you need in order to put together a license application and ultimately to craft conditions, new conditions for the license that you think will offer a better outcome in the future. And as Kevin will speak to, there is the opportunity for doing certainly collaboration and also reaching settlement agreements with licensees and the other interested stakeholders. Kelly, anything to add?
Yeah, in terms of the timeline for licensing, the process that is chosen at the outset, whether it's the ILP, the TLP, or the ALP, makes a difference. OMB did an analysis a few years back and found that the TLP had much longer timelines, like closer to 9 or 10 years to complete licensing, compared to the ILP, which was in the 5 to 7 year range. So the choice of the licensing process at the outset can make a huge difference. That choice is largely in the hands of the licensee, but they can be persuaded. And as participants in the process, you can object. And so I think it's a really important consideration when someone comes to you and says, we're doing a relicensing and we want to use the TLP, to look at whether or not that aligns with the issues that you're going to be dealing with. Like the TLP is definitely better suited and you can get through it more efficiently if you have a process with relatively few resource issues. If you're dealing with a lot of resource issues or the issues that you're dealing with are very, very complex, you will be better served timeline wise by going through the ILP.
Yeah, and it should be noted, ILP is supposed to be the default process. So that is the applicant needs to make a case as to why they're not doing the ILP. For almost 20 years, that was the case with most relicensings across the country that I saw. They were using the ILP. The last 5 years or so, there has been a resurgence of TLPs. And given what Kelly just said, you'd wonder, well, why would an applicant want to use a TLP rather than the ILP? Don't know for sure. Haven't got inside of their brains. My guess is they feel like it gives them more control. But I think that's a really important point to get together with other stakeholders, particularly resource agencies, and our recommendation is that you lobby heavily for using an ILP rather than a TLP. And hopefully it's going back to that situation rather than more TLPs going on out there.
Yeah, in my recent experience, there were a number of licensees in the Northeast that did request the TLP, and it was somewhat rare for FERC to deny that request, even over the objections of many stakeholders.
Yeah, and we saw the same out here, Kevin, and we're hoping that some change in management at FERC may reverse that trend, is the hope. All right, so Kelly, you want to do this one?
Sure. So I think what we're about to cover on the next slide largely holds true for whichever licensing process you're involved in, but because the integrated licensing process or the ILP is the default, we're just really going to focus on that. There are a few differences, but a lot of this holds true no matter which process you're a part of. So the ILP is characterized by 3 basic stages. The first stage is kind of this introductory phase where you're getting all of the information out on the table. It's being assembled into a pad. The second stage would be studies. and negotiating a study plan and then conducting the studies and getting the information. And then the third stage is where you potentially have the opportunity to engage in settlement, or you are negotiating agency terms and conditions, or mitigation measures, and just kind of there's a lot of discussion that happens around how we're going to address the issues that have been highlighted by the studies. And so the first two stages take place in the pre-application period, and then the third stage is kicked off when the license application is filed. And that's important because there can be a lot of interaction with FERC in particular in the first two stages. But once that license application is in front of them, ex parte rules kick in, and it's much more difficult to talk with them. You cannot talk about a specific project. You can only speak with them about generalities when you're engaging with FERC. So if you have something to say to FERC, it's important that that gets out in the first two stages, unless you're going to file it formally in a filing. So the integrated licensing process can be very consensus driven. If you have a licensee that is interested in building consensus, they can be very collaborative and collegial. I've also seen the opposite. But it was designed with consensus building and collaboration in mind. And then there's lots of opportunities along the way for agency, public, and tribal involvement. FERC is typically involved early in the proceeding in helping set a schedule, in doing scoping meetings, and just being involved, listening to what stakeholders have to say. And then there is a strong incentive, again, for collaboration and or settlement, excuse me, in terms of dealing with the mitigation of the impacts that the project is having. Dave, anything to add?
Yeah, I guess the only thing that I would add in there is that the best relicensings that I've been involved in are really problem-solving exercises. These are complex systems. You have a lot of resource issues. When licensees approach of that and provide the resources via their consulting team to help the entire group solve those problems, you come out with a much better outcome. The worst cases is where you're negotiating everything out of the gate all the time. You're negotiating what process you're going to use. You're negotiating what studies are going to be done, the outcomes from the studies. That takes a lot of effort. And quite often I have not experienced that necessarily leads to a better outcome for the licensees really, or anybody else. So working together on this stuff really helps. So actually, I think Kelly kind of covered that. So first stage, at least 5 years prior to license application, they've got to do their pre-application document, come up with the pad, and that's really a first chance for stakeholders to weigh in and figure out, what is the project, or did they scope it correctly? Did they capture all the issues? And you can provide comment back on that. And then hold meetings to develop study plans. So you've got this big project. How do you get the information you need to make decisions about what future license conditions should be? Anything else on that, Kelly?
No, I think you covered it.
So let's go back to the infamous flow chart here. So the first year, as it says at the top, hold on to your hats. You got a lot of work to do. I've been in processes where you're meeting 2, 3, sometimes even 4 times a week in order to get all this work done. As Kelly mentioned earlier, right out of the gate, the licensee files their pre-application document that gives you an idea of what are the physical pieces of the project, what are the resource issues that they think need to be dealt with, and you get a chance to weigh in on that. And then the big one right out of the gate, what process are you using? In my mind, you need to have conversations with other stakeholders, particularly the agencies, to make sure that everybody's on the same page that you want to request an ILP. And if the applicant um, wants to use a TLP, what's your plan for pushing back on that? As Kevin mentioned earlier, I have talked to a number of agencies that feel like, well, FERC's going to approve it anyway, so why try? I personally don't like that answer. I think it's always worth pushing back to try to get a better process because this really sets you up for the rest of the game. So it's worth putting it, but that requires some coordination and effort on all the stakeholders' part, really even before the process really begins. Um, so right away you get to comment on whether it's ILP or TLP, and then the commission will issue a notice, scoping document. You provide comments on that scoping document. And you notice that the timelines here in the numbers between each of these boxes, 30 days to provide comments on whether it's a TLP or ILP. That's not a lot of time. And then you've got another 60 days when the commission will act on that request. So if you look at each of these numbers between the boxes, they're not very long. So there's a lot that you have to do within that timeline. And then you start into the study uh, planning process. Licensee will typically hold meetings in the array of different resource areas that you have to cover. Certainly aquatics, biology, land use, recreation, and quite often those will be broken out into different groups with different subject matter experts. But you may cross over. I know for our organization, we certainly want to be involved in the discussions of flows regarding aquatics, but also for recreation. So you find yourself split between a lot of these different groups, and it's quite a bit of ground that you have to cover during that process. And then hopefully, again, if you can come to agreement with the licensee and come up with a study plan that addresses all those issues, that certainly helps and makes it go easier. If you don't come to agreement, then you go into a dispute process, which takes considerable time, effort, and energy. And then once you get all that done, then they actually will issue, if you go through the dispute process, that requires time, effort, and energy, and not many days. You look at the timelines there, like 20 days between um, when the process starts and whether the agencies are going to issue a dispute on what the study plans can be. So a lot of stuff to do within that first year. And that's where it's really important to be engaged, know that you have the resources to engage during that time period, and give it the level of commitment because this will really set you up for the rest of the process. Kelly, Kevin, anything to add there?
No, I think that's right. And it is, I cannot underscore how much work it is. Um, I will just add it's made better because you're going to have colleagues around you, both at other agencies and the NGO community tends to be rather aligned and grateful for agency participation and looking for allies. So you can share the work for
Yeah.
sure.
I think that's really key. Divide and share the workload.
Yeah, that's an important point because in a lot of cases, FERC will take notice if multiple stakeholders, agencies, NGOs come up with parallel comments. It's not uncommon to have identical or very similar language. So if FERC sees that that's all uniform, that's very important. But again, the agencies have their signature processes, which can be more challenging, especially in today's climate.
Yeah. And I think, and Kevin, that's a great point. And I think that's true throughout the process. The more alignment you have with everybody, the better off you're going to be. So the second stage, then we get out there and you actually go start conducting the studies to get all the information necessary for to make an informed decision on the application. Um, and then the licensee will provide a draft license application to the agencies and public to gather comments. I'm going to go back to the flow chart to talk about that a little bit. So potentially, not always, you get to take a little bit of a breather here while the studies are being done. But if you're actually involved in the implementation of those studies, so for instance, at American Whitewater, we'd always be involved with recreational flow studies. Agencies are involved with a lot of the aquatic studies if they have to go out and select transects in the river, things like that, and actually implementing. There is a bit of work to do there. But some of that lift or a significant amount is actually typically done by the licensee's consultants. So you get a little bit of a breather. So you go out, you do the studies, typically 2 field seasons to get that information in. But even before that information comes back, the licensee will prepare a draft license application. Um, I personally think this part is kind of a problem with the process because you typically don't have all the information, and yet the licensee is required to put together this license application with conditions that haven't been vetted. So they're either like a placeholder and, a licensee, what are they going to put out there for their draft license conditions? Probably the same conditions that they had in the previous license, which then that comes out and it makes everybody mad because, why is this the same as the last one? Um, but and also they have to disappear while they do this. It's a significant amount of work. So the licensee disappears while the license application's getting put together. They release it, and then everybody else is required, not required, but should be commenting on that license application. So then agencies and NGOs, we disappear for a while, really on a document, and this is my opinion, maybe not shared by others, that it's kind of a paperweight. You haven't even had a chance to discuss anything. So it takes a lot of time out of the process, and I'm not sure how much value. Sometimes licensees, if they are progressive and see which way things are going, they actually will put some conditions that are above and beyond what were in their previous license. But it just depends on how a licensee chooses to tackle that. And one thing that's important in looking at the overall ILP flowchart, there is no box in there that says time to sit down and negotiate. That does not exist. So you literally have to somehow within this process create that time to sit down with the licensees, look at the study information, and collaboratively, hopefully together, craft some license conditions. So you somewhere in this time period is when you need to try to figure that out. Other comments? Kelly, Kevin?
Yeah, it's also not uncommon for licensees to change their basic proposal when they file their draft application. And in the traditional licensing process, that's at the beginning of year 4. So in some cases, uh, the stakeholders and resource agencies will have to respond to issues or proposals that were not addressed early on. That may require supplemental studies or even additional studies. And that's how, in many cases, the traditional licensing process can drag on to the point where annual licenses are required. And again, anytime an annual license is issued, it basically continues existing conditions and puts off the implementation of mitigation.
Yep, good point. Um, this is one of my favorite Gary Larson's cartoons here. This is the life of an NGO in FERC relicensing. If you can't read, it says, "Still no money, huh? Well, let's see if Rudy and his wiffle bat can help encourage you." So I always feel like that's what we're out there with ineffective tools of persuasion. We're out there swinging a wiffle bat around, trying to get what we want out of the process. Because it is hard, with some entities, I mean, agencies with mandatory conditioning authority, they have legitimate power in the process. Certainly the licensee does, certainly FERC was. Some of us are left with cajoling and trying to make strong recommendations, but you don't actually have any, what I like to call with agencies with 4E conditioning authority have the magic pen, which brings about its own challenges too.
One of the other challenges that we've experienced throughout, my time in this arena is that while we know what the licensees, the value of the power that they are producing, how much they're getting per megawatt hour, we know how much they're generating, but we don't know their profits. So in a lot of cases, when you're trying to negotiate some of these terms and conditions, that puts us at a collective severe disadvantage. FERC is also not looking at whether a license order is profitable to the company. They're issuing the license with the conditions that they feel are appropriate, and it's up to the licensee to decide if they want to accept those conditions. And that comes in a lot, especially with settlement negotiations, which we'll get to a bit later.
Yeah. All right, Kelly, you want to do the third stage here?
Sure. So the third stage, again, this is largely after, well, it's after the license application has been filed and after the ex parte rules have kicked in. So your project level engagement with FERC largely ends at this point. But there's still a lot of work to be done between agencies and NGOs. So 2 years prior to the expiration of the license is when the final license application is due to be turned into FERC. And this is another opportunity to weigh in and gather comments. As Kevin mentioned, there's typically some changes between the draft license application and the final license application. And then, how realistic the final license application is depends on whether or not your licensee is listening. My experience is that agencies tend to be rather transparent about the mitigation measures that they would like to see, about the recommendations that they are planning to make, about the terms and conditions they are planning to require. And sometimes the licensees listen and they incorporate that, and sometimes they don't. So there is ample room for analysis and comment, particularly where you know that they are going to be asked to or required to do something, but it has been ignored in the license application. In this third stage, this is also where agencies are developing and submitting their terms and conditions and recommendations. Interventions are filed. I want to take a minute on interventions because they're really important. So an intervention is how you become a party to the proceeding. And being a party allows you to challenge the decision and ask for a rehearing later on, and then ultimately seek a remedy in the courts if you're still unsatisfied. So agencies, and Kevin can correct me here if I'm wrong, largely are allowed to just notify FERC that they are intervening. If you are a member of the public or an NGO, you petition to be included as a party to the proceeding. And there is a prescribed format and a hard and fast deadline. FERC they used to be lenient about interventions, and if you missed it, you just filed an intervention out of time, and you had a good chance of being joined as a party to the proceeding. But these days, they're pretty strict, and you have to have good cause, which they are construing as like in the hospital level of good cause for not intervening within the intervention statute. So be watching for that intervention deadline because it's very important.
Right, and those interventions tend to be primarily procedural. You don't have to, you don't have to put out your entire position or comments. Like with Interior, ours were simply like one page, and they maintained party status throughout the process. However, if there's an intervention in opposition, then that kicks off the whole ex parte process, and it makes it much more challenging. And that's something to be mindful of and understanding is important.
Yes. But usually it's just a matter of filing the requisite paperwork and then you become a party.
Yep.
It is among the easier things to accomplish in the FERC process. So the third stage also includes an energy bill. So in 2005, Congress graced us with the energy bill appeals process or alternative conditions process. And this allows the licensee and sometimes parties, I actually can't remember exactly where we are. I've looked at so many changes to this law over the years to submit alternative conditions to the agency terms and conditions to be considered. In rare circumstances, there will be a challenge to the terms and conditions, which then go through a really compressed, basically like a legal trial in front of an administrative law judge. I am a survivor of one of these procedures, and they are intense. Everybody lawyers up. I think it does the exact opposite of what the ILP was intended to do, which was create collaboration and open up the modes of communication between parties. And instead, the energy bill appeals process sends everyone's lawyering up in their own corners to defend their positions. So if you can avoid that one, I recommend it. It has largely fallen out of favor because the hydropower industry kept losing. And ALJs were finding that agencies had good reason for requiring the conditions that they required. So it isn't used as often, but should you find yourself in that situation, brace yourselves. It's a tremendous amount of work, and you will not do anything else for that brief period. So in addition to that, you will also receive the EA or the EIS from FERC. Oftentimes they are applicant prepared. This is another opportunity for filing comments and again, engaging on the record to state your position and see whether or not there has been adequate analysis of the impacts and a full range of alternatives considered. And then finally, when we've done all of that, when we've had water quality certifications issued and terms and conditions issued, and everything is in order, FERC will issue a new license, and that officially concludes the licensing process. Dave, anything to add?
Well, a couple things going back to the flow chart here. This just lays out a couple other pieces in this window. Again, as Kelly mentioned, any negotiation that happens on conditions really needs to happen before FERC issues what's called their REA notice, ready for environmental analysis notice. A couple of different strategies for expanding that negotiation window, which again is not included in the ILP. I've been involved in a number of relicensings where we've actually asked FERC to delay the issuance of the REA that allows us a little bit more time to work on it. So that's one way to expand that negotiation window that's been effective in the past. But once they do, as Kelly mentioned, you're off to the races. And she was not underselling the what I call here the trial type hearing bomb. Um, the problem, I mean, as backing up the other Far Side cartoon, one of the challenges when you're crafting those terms and conditions, you're in the process, you're getting all this information back, you've been commenting on the draft license application. Let's face it, you're kind of tired at this point. Yet, this is when you need to be at your best to craft these conditions because the words in the conditions matter a lot, which is why this cartoon is so appropriate, which says suddenly a heated exchange took place between the king and the moat builders. The king wanted the moat outside the castle. These guys are digging the moat inside the castle wall. I can't tell you how many times I've seen this where the words on the page are the same for everybody, but people have different interpretations about what those words mean. So, one recommendation I have here, hand a condition to somebody that doesn't know anything about the project and have them tell you what they think that it says. It happens more than you would ever think that people just when they come out of it have completely different interpretation about what the words on the page mean. So that part's really important to get that right. But anyway, so then they issue the REA notice, the terms and conditions come in, and then yeah, the licensee can challenge those. And the trial type hearing process was really created because of concerns that licensees had that agencies were writing conditions that did not have basis in what they called material fact, that they were just kind of inventing these things. The ones that have gone through this process, as Kelly has mentioned, have not borne that out to be true. I think overwhelming the administrative law judges who preside over these trial type hearings have largely sided with the agencies. The problem is they rarely go to hearing. What this process has really done is created a situation where the licensee can have bilateral negotiations with the agencies and everybody else is out of the room. Um, in my opinion, rarely getting to a better outcome for the river or the general environment in the project. So that's a real problem. I, again, my opinion, encourage agencies. It's a huge amount of resources to go through one of these things, but if you do, history shows that you will probably prevail. So it's worth it to go through that process, if nothing else, just as a deterrent to using this. And also, um, it's not only licensees that can file for a hearing. Actually, our organization filed for a trial type hearing primarily just to get us a seat at the table. If you file yours, then you've got to be part of that process also. So, expensive way to go about it, but it really, as Kelly pointed out, it really can blow up years of hard work in trying to reach settlement and reach conditions that are really in the public interest.
Yeah, another challenging element of this process is the REA notice triggers two other processes. The state's review and issuance of their 401 certification. So in many cases, the state agencies are not in a position to have actively engaged in the process up until that time. They may not have the staff, they may not have the funding to do that. The other process that's triggered is the National Historic Preservation Act, Section 106, which involves cultural and historic resources, and that's where the State Historic Preservation Officer, the SHPO, engages in the process as well. So, with in terms of the Park Service, when we have specific resources that are critical to us, in a lot of times we will try and reach out to the SHPOs before this deadline comes up and explain to them, here are the issues that we're dealing with, and try and get them on the same page. And that's where the coordination of filings and language can really help. One other quick note on, if you're requesting a delay of the issuance of the REA, that's something that the stakeholders and the applicant would normally want to take to FERC. There have been a lot of situations where we've had communications beforehand and they said, hey, look, we need more time. And we're like, yep, we're with you on that. We would file those jointly. But again, FERC doesn't always say yes. We had a project recently where FERC had basically had enough of the applicant failing to get their progress reports in. There were other situations and they finally said, nope, we're done. And they issued the REA. So that's when you have to start really scrambling.
All right. Oh, there's the bomb. Avoid the bomb. Don't use the bomb. Okay, so Kevin, off to you. I don't know, Risa, do we want to do any questions on that, or should we wait till we go through this? Your call.
You know, let's keep going. Let's keep going
Okay.
if we can. Yeah.
Okay.
Dave, I'm only seeing the first bullet and not the other bullets below that.
You want all of them?
Yeah, if you could, that would be great.
Him now?
Yeah, thank you. So the concept of settlement agreements is something that FERC has accepted over time. They issued guidance on settlement agreements. And the one thing that it really does is it provides an opportunity for all of the agencies, the NGOs, and the company, the hydro licensee or applicant, to come together and provide FERC with a framework for licensing conditions. In a lot of cases, the goal is to take the work out of FERC's hands and give them a document that they can simply incorporate those conditions into the license order. It tends to be important to make sure that the NGOs and the agencies are on the same page. So, for example, on the Deerfield, which was one of the first major settlement agreements in the Northeast, that was in the early 90s, there were some conflicts, real and perceived, between the whitewater boating community and the fishing community, in some cases between recreation and fisheries. So Park Service and the Fish and Wildlife Service, we would make sure to sort out any potential internal conflicts outside the public eye. And one of the early things that was done was, representatives of Trout Unlimited and American Whitewater at that time, New England Flow, which was one of the first organizations that engaged in the relicensing process. They kind of got together and sorted out, okay, how can we make this work, as opposed to coming up with positions that were conflicting. There were a lot of different interests that were involved, and again, this was, we were trying to kind of reach new ground here. The relicensing process that came out of the class in '93 was the first one under the amendments to the Federal Power Act, which involved a balancing between power and non-power values. So there was a lot of new ground to be broken. And we really, we worked collectively with the company, that's another key element of this. You want to go to the next slide, please? You can go to the next slide. Thank you. And that's the Monroe Bridge section, which had previously not had, it was basically a driveway. And on rare occasions, there would be water put down the driveway during natural flow conditions. You can go to the next slide if you like. Dave, you can go to the next slide. Okay, one more slide.
Why is it not moving here?
We're now looking at your desktop, Dave. Or
Uh-oh, why did that happen? Sorry.
No worries. But anyhow,
So I got to do a stop share and reshare here.
Okay. Well, I can keep going.
Yeah, go ahead. Okay.
So the Deerfield River was in Vermont and Massachusetts, and it had a lot of fisheries and habitat based provisions. Seasonally restricted drawdown levels to protect loons and waterfowl nesting. There were guaranteed flows to mimic natural flows for the cold water fishery and Atlantic salmon spawning. And there were also recreational releases, 32 scheduled releases from April to October in the Monroe Bridge section. So this basically opened up a whole area of scheduled releases for whitewater boating in a region that hadn't typically seen them. You had, 2 hours from New York, 2 hours from from Boston. So it really, an hour and a half or less from Albany. It opened up a tremendous opportunity for whitewater boating, and was a significant economic benefit to the region. There were also 106 scheduled releases at the lower segment, which was Fife Brook, which is class 2 and 3. The Monroe Bridge was class 4, and under some conditions, it could get up to class 5. They also provided flow release information, which was available 24 hours a day. And this was through a flow phone. So this was, again, this was early 90s. This was pre-internet. So now that's all out there in a much more significant and easily accessible way. Yep. And the picture on the right is Governor Weld of Massachusetts. We got him out there to go paddling with us. And one of the key elements at this point was, once we knew we had the governor on board and understanding the recreational benefits and the environmental benefits, that's when I think we knew we were gonna reach this agreement. You can go to the next slide. Yeah. So this settlement ended up preserving about 8,000 acres of land. There was a considerable improved access and hiking trails. So not only did we have the state of Vermont involved, but all of the appropriate and necessary Massachusetts entities. You have several people there from the State Executive Office of Environmental Affairs and Department of Environmental Management, which is today's DCR. There was also a relatively small environmental enhancement fund for watershed conservation, education, and recreational projects, and that fund is still ongoing. Okay, you can go to the next slide. Okay, so another project that we were involved with was 15 Mile Falls Settlement Agreement. And that was actually signed in September of 1997, right at the outset of the relicensing process. FERC accepted the settlement agreement in 1998, and the license was issued in April of 2002. A lot of crossover between the parties involved with the Deerfield, as well as New England Power, the same licensee for both of these. And one of the reasons that we all collectively got involved with this process early in the relicensing was because there was an impending change of ownership, and also to address the deregulation in the electric generation industry. You can click the next piece there that gives some of the bullets of this enhancement fund. So the power company initially contributed $3 million. A little over $2 million went to the towns which affected their tax revenues. So that was the payment in lieu of taxes. It was a pilot, involved protection of over 11,000 acres, 8,000 in the project boundary, and another 3,000 acres that was owned by the company outside the project boundary. Land protection was all endowed in terms of legal and title work, long-term monitoring and enforcement. That's another thing that's really important. If you're going to protect a large chunk of land, you need to have a process in place and funding in place to manage it. It was based on water generation. So it was a percent of their aggregate generation revenues. And it was expected that it was going to take 10 or 15 years to reach $15 million. Well, it actually happened very quickly because you had several historically high water years. So in the years since 2006, the fund awarded over $22 million. Several thousand additional acres of land was protected. And part of the criteria, and you can go to the next slide, resulted in us being able to preserve and to remove roughly 20, I think it was 22 dams. These are not FERC dams, and other significant water barriers. This is a picture of the Gale River. It's tributary to the Ammonoosuc in New Hampshire, and as you can see, very different from start to finish. I know a number of you have been involved with dam removal. So you can go to if you want to go to the next slide. So This fund set up an advisory committee to basically administer the fund. So we would meet every year a couple of times. We would review grant applications, and in most cases, we went through a pretty detailed process. The amount of information that we received was more detailed as time went on, and mapping technology was improved. The funds were held by a qualified conservation organization. In this case, it was the New Hampshire Charitable Foundation. One of the key elements of this kind of a settlement agreement is we had to show a direct nexus between fund expenditures and ongoing impacts associated with project operation, just as with any mitigation. So, for example, you can go to the next bullets. So, dam removal and acquisition of development rights and property, fish passage at non-hydro dams and unlicensed facilities, natural obstructions, and improving riverine habitat, especially in the riparian zone, adjacent wetlands, and water quality. So we couldn't just do anything that we wanted to do with this money. It had to be tied in with the kinds of mitigation that FERC would want to see if they were issuing a licensing order, and the kinds of things that they would put in for the most part with their own conditions. Okay, you can go to the next slide. And these were three very large dams on the upper Connecticut River. Okay, the next slide. So there were the three basic elements of this nexus to continuing adverse impacts: wetlands and riparian restoration, shoreland protection, restoring naturalized buffers, stabilizing eroding shorelands. We maintain wildlife riparian corridors. We established buffer zones, and you can go to the next couple of bullets. One of the things that we did was we required establishment of protection of riparian corridors through what are called meander easements. So if the channel would move based on flows and other conditions, the boundary of the easement would also move, because you could have in some cases 30, 40 feet laterally of erosion over one winter. So it was important to maintain the same amount of buffer. So we often required as a condition of a grant recipient to protect, anywhere from 50 feet to 100 or 250 feet, subject to a meander easement. So you wouldn't you wouldn't suddenly end up with a situation where you had 50 feet of protection and then that was down to 20 due to erosion. Okay, you can go to the next slide. So this project is at the Holtwood Dam on the Susquehanna River in Pennsylvania. And this was a situation where it wasn't a typical process. This was a license amendment. So the company had planned to almost double the size of the existing powerhouse. And as a result, they had to dig a new tailrace channel, which basically wiped out the existing series of existing whitewater play spots. So part of the settlement agreement involved literally constructing new play areas that were commensurate to what had been lost. There was also a significant land protection component. There was land, including land within the project boundary, which was actually transferred to a conservation organization outside the project boundary. So we needed to do a formal boundary adjustment. This is also a key milestone in efforts to secure a greenway corridor along the Susquehanna River. So all of these settlement agreements were on projects that didn't involve formal park units. And that was just kind of how things worked out. The Park Service's hydro program was not specifically to be focused on park-specific resources. That developed kind of by chance over the last 15 or so years when virtually all the projects that I was involved in the Northeast did have a park unit component. Okay, let's go to the next slide. You can go to the next slide here. Okay, to the next slide, please. Okay, so this agreement on the Penobscot River involved removal of the Milford Dam and the Vesey Dam, which had been the first, the head of the tide dam, basically. So the removal of these two dams allowed for the natural passage of Atlantic salmon up to and past the Penobscot Indians reservation at Indian Island for the first time, and I believe it was 120 years. It was a real milestone. I think a couple of years earlier, the Edwards Dam had been removed, and that was the first dam that was on the Kennebec River. That was the first dam that was ordered removed by FERC over the objections of the licensee. In this process, all of the stakeholders, the state and federal agencies, a number of NGOs, and the company all worked together to establish a fund. It was basically an organization, Penobscot River Restoration Trust, which was formed. The dam licenses were transferred to that entity, and then they were removed as part of that entity's work in that area. Obviously, funding went that way. But one of the key elements of this agreement was that the administration at the time, this was the first Bush administration, and this is important to keep in mind in all of these type of agreements. When we were collectively fairly sure that we were getting close, we reached out to the administration to make sure that they were going to be supportive of it. And one of the things they said was that even with the removal of these two dams, there can be no net loss of hydro generation. So we were able to show definitively that even though these dams were removed, one of them was raised, one of the remaining dams was raised slightly, and the transfer of equipment, upgrades, efficiency improvements actually resulted in a net gain of aggregate hydro generation. And I think that's one of the things that's still important to keep in mind today under the current administration. They're certainly in favor of hydro, not so much removing dams. So if there is a proposal to remove a dam, you should look to a way to either match or increase that generation through efficiency improvements or other methodologies that would achieve that. Because again, if you just come in at a late stage and say, hey, we're removing these dams, and the company agrees to do that, you may have a significant glitch if the administration is not going to get behind that. So you can go to I think we're at the last slide here. So in terms of the timing of settlement agreements, they can be initiated well before or during a licensing proposal or an original licenses. The key ingredient, obviously, is that the applicant must be willing to participate. In cases where you have the absence of an interested hydro operator, it's very crucial to coordinate the comments of the stakeholders and the resource agencies and the NGOs so that you can present a unified position. That can be done in the form of filing consistent comments to FERC saying the applicant has position A, we're taking position B, here's how we're justifying it, scientifically based on studies and all of that. And that'll give FERC an opportunity to understand your position. One of the other key issues, and there are still settlement agreements that are in process. We had a large agreement that had a lot of recreational and water quality and land improvements associated with Northfield Mountain and Turner's Falls in Massachusetts. That's still being reviewed. It's in the 401 process. There are a lot of technical issues that are going on, so it may be a little while. We also had one on the Mongop River, which has also not been relicensed yet. One of the things we did on the Mongop River was that we negotiated with the state of New York, we collectively negotiated with the state of New York to ensure that the settlement agreement itself, the terms of the settlement agreement, would be incorporated into the state's 401. Some states have 401 authority, which allows them to include recreational and aesthetic interests and those areas. So by doing that, we basically protected the settlement agreement from FERC. I don't know if that's the best way to say it, because that way FERC has to incorporate all the terms of the 401 into their license. And when the terms of the 401 include the settlement agreement, that's a way to get it to ensure that it comes in. And in fact, when FERC's EA came out, they really missed a lot of the rationale behind a lot of the settlement terms. So again, that's an ongoing process, but by doing that, we were able to really make the settlement agreement much tighter. And again, that's not always going to be the case. It was brought up earlier that a lot of times the state 401 agencies are not, willing or able to engage in the process until the REA notice comes back. But I think the key of the settlement agreements is to get, for example, the fisheries and the boating communities, get them together to try and sort out some of their differences, make sure the states are on board, and then take it to the company. Because if you come to the company with conflicting positions, they will try and divide and conquer. They will try and have partial settlements with this entity, partial settlements with that entity. Obviously, it's best if you have one large agreement that encompasses all of this. And again, it's pretty critical to have the company on board with these. So again, happy to take questions or move it back to the group.
Yeah, feel free. The group is not that large today. If you would just like to take yourself off mute, announce, identify who you are, and just ask any questions you have. You may have overwhelmed this audience, you guys, your experience.
I see that Tom Christopher is on. Tom, when I was putting this presentation together, I found some of the old Deerfield slides. So send me a note and I can get you some of these photos. Okay, we had Governor Weld out there.
We'll do that, Kevin. And I would like to commend all my colleagues for a timely presentation that was right to the point. Of course, my experience goes all the way back to the early days of the Deerfield and gone through a lot of different projects and settlements here in New England. And quite frankly, very grateful to have been part of this process and have the ability to work with a whole bunch of really wonderful colleagues. And I think one of the best things that comes out of settlement agreements is oftentimes you begin the process with other stakeholders and you look at each other across the table and you're bitter enemies. But by the time the settlement agreement gets put together, you recognize that everybody's got a reason to sit at the table, and everybody's reason to sit at the table is just as valid as yours. So consequently, you have an opportunity to turn that enmity into becoming good friends. And one other point that I would make is that here in New England, where we have a relatively small geographic area, we end up oftentimes working with the same people as stakeholders, the same agencies, and occasionally owners who now own more than one or two facilities here in New England. So you are not only building relationships with stakeholders and agencies, you're actually building a relationship with the applicants as well. And I think one of the reasons that made the relicensing of the Deerfield so unique was the fact that once we got through fighting with each other, it became very apparent that the New England Power Company was an enlightened company that was willing to look towards the future rather than dwell on the past. Once again, thanks for everybody. That was a great presentation.
Yeah, and I'd like to expand on one of the points that Tom mentioned about the perceived conflicts. You know, a number of us had been involved with some relicensings with Niagara Mohawk. This is back in the early mid 90s. And you know, we collectively, the stakeholders, the NGOs, the resource agencies, we'd come in and we'd sit at a big table, and then there'd be a big gap, and then the company would be sitting at another big table, and there'd be this gulf between us. And we had a couple of projects that, you know, we really never quite got there. And then they had a new person that came in, and I was, you know, I was having breakfast with him before one of the meetings, and the process, and he said, you know, why don't we reshape the room? Everyone looks like they're on opposite sides. And I said, yeah, let's make it just a big round table. So before the meeting started, we reshaped the room and we made it a big round table. And we also suggested that instead of everybody leaving to go to lunch separately, that they have lunch brought in. So we all sat around a table collectively, and you know, we asked everybody to intersperse between the tables. If they wanted to talk privately, they could get up and go and do that. And they brought lunch into the room and we all sat down and we ate together. Well, that process in about 7 or 8 months resulted in a settlement agreement, whereas we hadn't in earlier processes where there was this physical gulf between the parties. So sometimes it's as simple as arranging the room and trying to foster, you know, social interactions between the company and the stakeholders. And it doesn't have to be, you know, an adversarial process. In a lot of cases, when the power companies had local, you know, they had a much stronger local presence, it turns out that, you know, kids were on the same softball team, or they were at, you know, different projects in school together. And there became that personal connection. And I think that helped us to understand, hey, we're all talking about the same resource. We all use these resources. It's harder nowadays when you have power companies that are owned from afar. But there's still, I think it's still important to make a personal connection with the people that you're negotiating with. Otherwise, it's largely adversarial.
I've always thought it's amazing how much goodwill you can get by buying people lunch. It's just and Tom, thank you for helping to write the book on how to do this.
Well, as I said, Dave, I'm really grateful to have been able to participate in this process. And my involvement was basically selfish. I was only interested in water for kayaking, and as we were fighting the good fight, we became involved in also a learning process that certainly caused us as boaters to look at the projects with a much broader perspective. So it wasn't, you know, just about whitewater. And I think that certainly our interest was very important in stimulating other stakeholder groups to get involved, largely because they thought all whitewater boaters were crazy. And you know, we would have conflicts with lake owners that didn't want water levels to go up and down. We would have conflicts with fishermen, and we would have conflicts with folks that were land-based organizations because they thought that raising water levels was going to cause ecological damage along the riverways. So, you know, I think that it's great to employ the integrated licensing process, and as Kevin and Kelly And Dave has said, the quicker you can get to work collaboratively with your stakeholder interests, the better off you're going to be. You have to remember that, we are not the enemy amongst ourselves. The enemy is the power company. They're the ones that have had control over a resource and taken it away from the public for many, many years. And now is these once in a lifetime opportunities to balance off that equation.
Thanks, Tom. Yes, it's great to see you. Any other questions from the audience? Please don't be shy. And if there aren't, we can call it a day and give you back a little bit of your afternoon. So I put in the chat a link to a survey. We'd love to get some feedback from you on how you viewed the session. And with that, I'd just like to thank Dave and Kelly and Kevin one more time. We started talking about doing this session months and months and months ago. So thanks for your patience and for putting it together, and for Tom and others for attending today. So thank you so much, and good luck to us all.
Thanks,
Thanks, everybody.
Lisa.
Take care.